This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Welcome to the Luxembourg Fundcast. Okay, let's unpack this. Picture this. You're operating a financial structure in Luxembourg, a dynamic securitization vehicle known in the market simply as an SV. Luxembourg is absolutely a prime location for these chains. The framework is known for its flexibility, its legal certainty. It makes it really attractive for, a wide range of transactions. But as you know, the financial world is interconnected. So what happens when your Lux SV needs highly specialized expertise from abroad? Let's say specifically from a Swiss financial advisor, someone with deep market knowledge or maybe unique insights into a particular asset class you're holding or looking to acquire.
Yeah, it sounds simple enough, doesn't it? You find the best expert out there, you sign a contract for advice, straightforward commercial need.
Right.
But you've really hit the nail on the head there. That's the core of the puzzle. In this highly regulated world of cross-border finance, bringing in that foreign expertise, well, it triggers complex regulatory questions. And crucially, these questions pop up in both countries involved. So the fundamental challenge really is, how do you leverage that super valuable expert advice coming out of Switzerland without that relationship getting seen by regulators as the Swiss entity actually managing your Luxembourg SV?
And that potential recharacterization, that's not just some theoretical risk, is it? The stakes are genuinely high here.
Oh, absolutely.
If that Swiss advisor's activity is seen as unlicensed management under Swiss law, well, they're facing serious issues. And for the Luxembourg SV, it sets off alarm bells for the CSSF, that's Luxembourg's financial regulator, the Commission de Surveillance du Secteur Financier. They could start asking, is your SV just a dormant, empty shell, a letterbox company with no real substance?
Right.
Or maybe even worse, is it actually an unregulated alternative investment fund, an AIF, being managed by someone who doesn't have the required license? An alternative investment fund manager or AIFM license.
And any one of those scenarios leads to significant, potentially show-stopping regulatory problems. It's a perfect storm, really, of potential issues that all converge on how you structure that cross-border relationship.
It just highlights how critical it is to make sure the legal form matches the operational reality.
It does.
So for this deep dive, you've shared with us some really insightful material that goes right into the specifics of this exact cross-border puzzle, focusing on that interaction between a Luxembourg SV and a Swiss advisor.
Yes, and our mission today is to carefully break down this complex regulatory chessboard. We need to identify the key rules, the ones coming from Luxembourg's own securitization framework, then look at the distinct landscape of Swiss financial regulation, and also see how the overarching EU principles, like those in MiFID II, the Markets in Financial Instruments Directive, kind of provide a harmonizing layer over it all.
Okay.
Then we'll zero in on the most crucial document in this whole setup, the advisory agreement itself. We need to analyze how this contract must be drafted really carefully to navigate these intertwined regulatory requirements and, thread that very fine needle.
And we're not just looking at the contract drafting in isolation, are we? We'll explore the practical side, too. The negotiation dynamics, what costs to expect, the timelines involved.
Right.
And crucially, because signing the contract is just the start, we need to talk about the ongoing operational discipline required after the agreement is signed. How do you actually make sure you stay compliant day to day and avoid those unintended consequences we talked about?
That's key.
We want to show you what's really important here. Connect the dots between these different legal regimes and make it clear why getting the specific challenge right absolutely matters if you're operating or advising these kinds of cross-border financial structures.
It really comes down to achieving both legal certainty through that careful drafting and maintaining operational integrity through, let's say, rigorous governance.
Okay, so let's start where the structure begins. The Luxembourg Securitisation Vehicle, the SBD. As we say, it's the foundation, rooted in that flexible, well-established framework.
That's right. The foundation is the Law of 22 March 2004 on securitization. It's what's known as an opt-in law. Entities actively choose to be governed by it because it provides a very specific and usually beneficial legal, regulatory, and tax regime designed just for securitization activities.
And that flexibility is why Luxembourg has become such a major hub for these vehicles.
Exactly.
And the definition of securitization itself under Article 1 of that law, it's pretty broad, isn't it?
It is very broad. Essentially, it's about an SV acquiring or assuming risks tied to various assets, could be claims, other types of assets, even obligations assumed from third parties, and then financing that risk assumption by issuing financial instruments. The key is that the value or return on those instruments depends on the performance of those underlying risks.
And that broad scope allows for a huge range of potential assets, doesn't it? It's not just typical loan portfolios.
Not at all. We're talking intellectual property rights, future income streams from contracts, real estate debt, trade receivables. The list is, well, quite extensive. That breadth is a big part of why the Lux SV is so useful.
And the material you shared highlights that the law got a major update back in February 2022. This wasn't just tweaking things, right? It introduced some significant changes.
Very significant. It aimed to make the framework even more robust and align it better with evolving market practices and, importantly, EU regulations.
Yeah, and two key changes from that 2022 update really seem relevant for our discussion today. First, the expansion of how SVs can finance themselves.
Right. Historically, SVs mostly issued securities. The updated law explicitly says SVs can now be partially or even fully financed by taking out loans. This gives much more flexibility in structuring the capital stack.
And it brought the Lux law closer to the EU securitization regulation, too?
Exactly, which also acknowledges loan financing. It was an important alignment.
And the second big change, maybe even more crucial for our discussion on advisory roles, is this explicit permission for active management.
Yes, this was huge. Before 2022, there was, let's say, some ambiguity, especially around assets like loans or debt securities. Some interpretations lean towards requiring passive management. The updated law now clearly states that for SVs that do not issue financial instruments to the public, the active management of portfolios consisting of debt securities, loans, or other debt instruments is explicitly permitted. This was a real game changer. It acknowledged the reality that managing these kinds of assets often needs dynamic decision-making, not just passively holding them.
That active management capability is vital, but it immediately brings us to that critical fork in the road for any Lux SV. Are you regulated or unregulated? Because that active management permission applies specifically to the unregulated SVs, doesn't it?
Precisely, and this distinction is key to understanding why these external advisory structures are so common. The vast majority of SVs in Luxembourg are not directly supervised by the CSSF. Direct CSSF supervision isn't automatic. It's linked to very specific criteria about how the SV issues its financial instruments.
Okay, and what is that trigger? What makes an SV fall under CSSF supervision?
According to the 2004 law, and based on long-standing CSSF administrative practice, supervision is triggered if the SV issues securities both to the public and on a continuous basis. If either one of those conditions isn't met, the SV remains unregulated by the CSSF.
Okay, let's break those down. What does to the public mean in this context, according to the source material?
Based on the material, to the public generally means the offer isn't exclusively targeted at professional investors, as defined under MiFID II. It also includes offers where the denomination of the securities is less than 100,000 euros, or if the distribution isn't done via a private placement. So basically, if you're offering broadly to non-professional investors or in smaller chunks, that usually counts as to the public.
Right. And the other condition, on a continuous basis, that sounds a bit more subjective. How does the CSSF view that in practice?
Well, the CSSF's administrative practice, which we see referenced in various circulars and communications, generally interprets on a continuous basis as meaning an SV makes more than 3 separate issuances to the public within a single financial year.
More than 3.
Yes. And importantly, this is assessed on an aggregate basis across all compartments if the SV has them. So if an SV issues publicly 4 times in 1 year, maybe through different compartments, it's considered to be issuing on a continuous basis and would likely trigger supervision.
Okay, so for our deep dive today, we're really focusing on that typical scenario, the unregulated SV. This is the vehicle raising capital probably through private placements, keeping any public issuances below that 3 per year threshold, and likely issuing in denominations of 100,000 euros or more.
Exactly. And this is precisely why the relationship with a Swiss advisor becomes so relevant. Because even for these unregulated SVs, the CSSF has a very clear, long-held position on substance and delegation. They apply what's called a substance over form doctrine.
Meaning they look past the labels.
Precisely. They aren't satisfied if a Lux SV is just a name on a mailbox. They look behind the legal structure to see what's actually happening operationally.
So the SV can't just be an empty shell.
It absolutely cannot. It can't be a mere letterbox company. The SE's own governing body, its board of directors or managers, depending on the legal form, must genuinely retain ultimate control and responsibility for the vehicle's strategy and its activities.
The delegation is allowed, right? Like for accounting or administration.
Oh yes, the law allows delegation of various functions, including advisory services. But the key is that the board must demonstrate that it effectively supervises those delegated activities.
And what does effective supervision actually require from the board in Luxembourg?
It requires sufficient substance in Luxembourg. This means having qualified people on the board, or at least access to qualified personnel locally, who can understand the business, who can challenge the advisors, and ultimately make informed, independent decisions.
Okay.
It also means the board needs unfettered access to all relevant documentation, reports, and information from the advisor whenever they need it. And crucially, the ultimate decision-making center, the place where the strategic and significant investment decisions are actually made, based on that advice, that center must remain firmly in Luxembourg. That's non-negotiable from the CSSF's perspective if you want to prove genuine substance.
Right. That substance requirement in Luxembourg really sets the stage. You need real decision-making power located there. Okay, now let's pivot across the border and look at the Swiss advisor. This brings Switzerland's regulatory framework into the picture, mainly through the Financial Services Act, FinSA, and the Financial Institutions Act, FINIA. These came in January 1st, 2020, right? A big overhaul.
A very big overhaul, yes. They aim to boost client protection and also align Swiss rules more closely with some EU standards, like MiFID II in certain areas.
And within FinSA and FINIA, what's the absolutely critical distinction for our Swiss advisor in this scenario?
It boils down to portfolio management versus investment advice. This distinction is the absolute razor's edge. It determines whether the advisor needs a license from FINMA, the Swiss Financial Market Supervisory Authority.
Okay, let's define those terms clearly under Swiss law. What exactly is portfolio management or Vermögensverwaltung?
Right, so under FINIA, this is defined as managing assets on a discretionary basis for clients. This is a licensable activity supervised by FINMA. The absolute key trigger, the thing that shifts you from advice to management, is having discretionary power over the client's assets.
Meaning the advisor can act without asking first?
Exactly. It means the advisor can make investment and divestment decisions. They can execute transactions, all without needing the client's specific prior approval for each individual action. If a Swiss advisor is doing that, effectively managing the assets, and they don't have a FINIA portfolio management license, they're operating illegally. Full stop.
Okay, crystal clear. So investment advice and Lagerberatung, how does that differ?
So under FinSA, this is defined as providing personal recommendations related to transactions in financial instruments. Now, importantly, providing investment advice is considered a financial service under FinSA.
Ah, so there are still rules.
Yes, exactly. It means the advisor is subject to certain FinSA rules of conduct, things like client classification, doing suitability or appropriateness tests, providing certain information. But, and this is the crucial point, the activity itself of providing advice does not require a FINMA license under FINIA. FINMA does not license investment advisors as a separate category needing prudential supervision like it does for banks or asset managers.
So the bright line for the Swiss advisor is purely about discretion.
It really is. The presence or absence of that discretionary power is the fundamental differentiator between non-licensable advice and licensable management. Swiss law even breaks down advice further.
Oh.
Yes, there's transaction-related advice, which is just advice on individual buy or sell decisions, maybe without considering the client's whole portfolio. That triggers a less demanding appropriateness test under FinSA.
Okay.
But then there's portfolio-related advice. This is where the advice does take the client's entire portfolio situation into account when making recommendations. This is seen as higher risk by Swiss regulators.
Closer to management.
It's closer to the line, yes. It requires a full suitability test, which means the advisor needs a much deeper understanding of the client's financial situation, their knowledge, experience, and investment goals. While it's still technically advice, because it considers the whole picture, it naturally sits closer to that regulatory perimeter of discretionary management.
The source material also mentioned a new FINMA circular on rules of conduct coming into force January 1st, 2025. How does that impact this?
Right. That circular basically reinforces these distinctions and puts a stronger emphasis on transparency. It gives more detailed guidance on how financial service providers need to implement the FinSA conduct rules, including how they document client interactions and those suitability or appropriateness checks.
So more paperwork.
In a sense, yes. But more importantly, for an advisor operating near that advice management line, This increased scrutiny and the demand for clear documentation proving the advisory nature makes having that clear contractual separation and the operational proof even more vital. You need to show how you determined the advice was suitable and that it remained non-discretionary.
What about the cross-border element from the Swiss side? Does FinSA apply if the advisor is in Switzerland, but the client, our Lux SV, is in Luxembourg?
That's a good question. FinSA's cross-border rules mainly focus on financial services offered to clients physically in Switzerland. So the primary risk for the Swiss advisor here isn't really about violating Swiss rules on marketing into Luxembourg.
Okay.
The main and most significant risk is that the service they are performing from Switzerland gets deemed unlicensed portfolio management under FINIA. This happens if they are found to be exercising discretion over the SV's assets regardless of where those assets or the client are located, because the unlicensed activity is originating from Switzerland.
Makes sense. And the client advisor register in Switzerland. Does the Swiss advisor need to worry about being registered?
The material points out a key exemption here. Generally, client advisors who work for foreign financial service providers like our Swiss firm advising the Lux SV don't need to be entered into the Swiss Client Advisor Register if they exclusively provide services to institutional or professional clients.
And a Lux SV would qualify?
Almost certainly. A Luxembourg SV, especially an unregulated one doing private placements with sophisticated investors, would typically be classified as a professional client under Swiss law. So while that register is a big deal under FinSA for advisors dealing with retail clients, it usually doesn't apply to the individual advisors at the Swiss firm serving this specific type of Lux SV client.
Okay, so we have Luxembourg demanding substance, demanding that the SV board keeps ultimate control. And we have Switzerland drawing this sharp line based on discretion advice is okay without a license, management needs one. Now let's bring in the EU layer, MiFID together. How does that fit into this picture?
Right. Well, Luxembourg is an EU member state, so its financial regulation is inherently tied to EU directives. MiFID 12 is highly relevant because it standardizes the definition of investment advice across the whole EU. While the Lux Securitization law is specific, it operates within this broader EU context, and the CSSF certainly considers EU principles.
And how does MiFID define investment advice? Is it similar to the Swiss definition?
It's similar in spirit, yes, but uses EU-specific language. Under MiFID II, and based on detailed guidance from ESA, that's the European Securities and Markets Authority investment advice, means providing a personal recommendation to a client. This could be upon the client's request or initiated by the firm itself, and it relates to one or more transactions in financial instruments. The key phrase there is personal recommendation.
And what makes a recommendation personal under MiFID II?
ESO guidance clarifies this. A recommendation is personal if it's presented as suitable for that specific person, or if it's based on considering that person's individual circumstances. It implies a value judgment by the advisor about whether a particular investment is appropriate or suitable for that client.
So if I just give you factual market data, price history, sector performance, that sort of thing, is that investment advice under MiFID II?
No, generally not. Just providing objective, factual information about an instrument or market conditions without adding that layer of personal judgment, linking it to the client's specific situation or suggesting a course of action isn't considered investment advice under MiFID II.
Okay.
So while the EU framework influences Luxembourg, the really critical distinction for keeping the Swiss advisor compliant is driven more directly by that Swiss law threshold of discretion. It just happens that this aligns conceptually with the MiFID line between giving non-binding recommendations, which is advice, and actually making decisions for the client, which is management.
Right, that makes sense. So we've got the Lux requirement for the SV board to be the ultimate decision maker, the Swiss need for the advisor to avoid discretion to stay license-free, and the EU defining what advice actually means. How do these all connect? Where's the synergy or potential conflict?
This is really where the elegance, but also the challenge of this structure lies. The actions the Luxembourg SV board needs to take to prove substance and control to the CSSF.
Like reviewing reports, asking questions, documenting decisions.
Exactly. Those actions, debating options, formally recording their independent decisions in detailed board minutes, are precisely the kinds of things that simultaneously demonstrate to FINMA in Switzerland that the Swiss advisor lacks discretionary control.
Ah, so the same set of actions satisfies both regulators, just viewed through different lenses.
Precisely. By ensuring the SV board is genuinely active and making the final calls in Luxembourg, you're meeting the CSSF substance requirements, and you're building concrete evidence that the Swiss advisor isn't making discretionary decisions from Switzerland. This keeps their activity within the safe harbor of non-licensable advice under Swiss law. This dual-purpose aspect is absolutely fundamental to making this work compliantly.
That tight link means the advisory agreement itself isn't just some standard contract. It's doing some serious regulatory heavy lifting.
It really is. You have to think of the agreement as a critical dual-purpose regulatory instrument. Its main job, beyond just setting out commercial terms, is to be the foundational blueprint that shows regulators in both Luxembourg and Switzerland that this is a legitimate advisory relationship, not some kind of disguised management setup.
And the guiding principle for drafting this crucial document.
Substance over form, once again. The contract must state in absolutely clear terms that the Swiss party has a non-discretionary advisory role. But critically, the words in the contract must also accurately reflect and, importantly, support the operational reality.
Because regulators will check both.
They will. They'll compare the contract to what's actually happening. If your contract says advice only, but the board minutes consistently show the advisor dictating terms and the board just nodding, the contract won't protect you. The reality trumps the paper.
Okay, let's dig into the specific clauses then. The preamble and recitals, often seen as just boilerplate, you're saying they actually matter here.
They absolutely do. While they don't create binding obligations themselves, they set out the intent of the parties right at the start. The recital should clearly state that the Luxembourg SV is seeking non-binding investment advice to help its board make informed decisions.
And that the advisor is just providing advice.
Yes, and that the Swiss advisor is being hired solely to provide that non-binding advice with absolutely no authority to make investment decisions, execute trades, or manage the portfolio on a discretionary basis. Having that clear statement of intent up front can be very powerful evidence if questions ever come up later.
Makes sense. Moving to the real core, the scope of services. The what section. This is where that regulatory line gets drawn in the sand.
This is arguably the single most critical section in the entire agreement. It needs meticulous drafting to clearly mark out the boundaries. The best way to do this is usually with exhaustive positive lists outlining exactly what the advisor will do and, just as importantly, explicit negative lists detailing what the advisor is expressly forbidden from doing.
No room for ambiguity.
None. Ambiguity here is your worst enemy.
Okay. Based on the sources, what kind of activities are clearly okay, clearly fall under non-discretionary advice?
Permissible things include providing market research and analysis, identifying potential investment opportunities based on criteria previously set by the SV board, doing due diligence on potential assets or counterparties, and then presenting those findings in a report to the board.
So informing the board.
Exactly. Providing non-binding recommendations, market commentary, maybe strategic advice on general portfolio construction principles, but not making specific binding allocation decisions. Introducing potential counterparties, like originators or servicers, for the SV board to consider and potentially contract with directly. The key is always that the output is information, analysis, recommendations, or introductions, all presented to the board for their decision.
And that crucial negative list. What absolutely must the contract say the advisor cannot do?
This list is vital for proving the lack of discretion. The agreement must state explicitly that the Swiss advisor has zero authority to make investment or divestment decisions for the SV. None.
No decision power.
Right. They cannot execute transactions, buying or selling assets, entering derivatives. They cannot enter into agreements that legally bind the SV. They cannot instruct third-party service providers like custodians, administrators, or loan servicers. The agreement needs to hammer home that all final investment and operational decisions are the sole and exclusive responsibility of the SV's board, acting in Luxembourg, using its independent judgment based, in part, on the advice received. This negative list creates that essential contractual firewall against being recharacterized as management.
The examples in the source material were useful here. The yes list, research, identifying assets, non-binding recommendations, the no list, final decision, executing transactions, managing servicers, and that gray area like monitoring performance.
Exactly. And that gray area like performance monitoring needs very careful wording. Monitoring performance can be an advisory task, but it has to be framed strictly. It should be about providing factual reports to the board on how assets previously recommended are doing against benchmarks, maybe monitoring the overall portfolio against high-level strategic criteria set by the board.
It can't become active management.
No, it absolutely cannot drift into active day-to-day portfolio adjustments based on that performance data. That crosses the line.
Okay, scope defined with extreme precision. Check. What about liability, indemnification, and the standard of care? How does this section play into signaling an advisory role?
This is another key indicator regulators look at when assessing the true nature of the relationship. Standard market practice for pure advisory agreements, as the source material notes, is to limit the advisor's liability significantly. Typically, the advisor is only liable for losses that directly result from their own gross negligence, willful misconduct, or fraud.
Not simple mistakes.
Generally not simple negligence or errors of judgment or just bad market outcomes.
And why does that limitation signal advice, not management?
Because a discretionary portfolio manager, the one actually making the decisions and holding the assets, typically has a higher fiduciary duty. They're usually held to a higher standard of care, often including liability for simple negligence. So, by limiting the advisor's liability to that higher threshold of gross negligence or willful misconduct, the parties are contractually reinforcing that this is an arm's-length, non-fiduciary relationship in the management sense.
It reflects that the SV board keeps the decision power and therefore the investment risk.
Precisely. The SV board assumes the primary investment risk for the decisions it ultimately makes, even if those decisions were informed by the advisor's input.
How would that liability limitation typically be worded?
A common formulation might say something like, the advisor shall not be liable for any loss, damage, or expense, except to the extent finally determined by a court of competent jurisdiction to have resulted solely from the gross negligence, willful misconduct, or fraud of the advisor. Something along those lines.
And you mentioned a savings clause being essential.
Yes, absolutely essential, especially with regulators increasingly focused on client protection everywhere. You need a clause that makes it clear that nothing in the agreement, including the liability limits, waives, limits, or modifies any rights or protections the SV has under applicable securities laws or regulations that cannot be legally waived by contract.
You can't contract out of mandatory rules.
Exactly. This prevents regulators from arguing that the agreement tries to improperly strip away non-waivable client rights, maybe under FinSA conduct rules in Switzerland, or potential EU regulations.
Got it. Okay, let's talk fees and compensation, the why section. How does the way the advisor gets paid signal whether they're advising or managing? This sounds crucial.
Oh, it's one of the things regulators look at most closely. Why? Because it reveals the advisor's underlying economic incentives. The fee structure must be clearly and logically linked to the delivery of specific advisory services. It should not look like compensation for managing the overall SV portfolio.
And the fee structure that raises the biggest red flag, the one to absolutely avoid if you can.
Without a doubt, it's the assets under management fee, the AUM fee. Charging a fee based on a percentage of the total value of the SV's portfolio. That is the classic compensation model for a discretionary manager.
Because it ties their pay directly to the portfolio size and performance.
Exactly. It creates this direct, ongoing financial incentive linked to the very portfolio they're supposedly only advising on. Trying to defend an AUM fee structure as being solely for non-discretionary advice is extremely difficult, borderline impossible, in front of a regulator. It just screams de facto management relationship.
So what fee structures are more defensible for a pure advisory role? What should people aim for?
More appropriate and much more defensible structures would include things like a fixed retainer fee. This pays the advisor for their availability, their general expertise, keeping capacity ready, regardless of specific deals or the portfolio size. That's clean. A success fee or an arranger fee can also work. This is typically a one-time fee paid when a specific transaction or asset acquisition, which the advisor worked on, successfully closes. It's clearly linked to the advisory or arranging effort for that specific deal, not ongoing performance of the whole portfolio.
Right.
Project-based fees are also good, paying for specific, defined deliverables, like a detailed due diligence report on one potential target asset. Again, clearly linked to specific advisory work product.
What about performance fees? They're common in finance, but are they dangerous territory here?
They are very tricky and need extreme caution in a pure advisory context. If you absolutely must have one for commercial reasons, it needs meticulous structuring to avoid looking like management pay.
How could you possibly structure it?
Ideally, any performance fee should be linked very specifically to the performance of one particular asset or one specific transaction that the advisor directly provided advice on. And it should be measured over a defined period against a clear, objective benchmark. Critically, it should not be tied to the performance of the entire SV portfolio.
So you're rewarding good advice on a specific thing, not overall management results.
That's the argument you need to make. But honestly, any performance fee tied to the aggregate portfolio performance will be viewed with intense suspicion by regulators and dramatically increases the risk of being recharacterized as management, best avoided if possible.
Okay, fee structure is a huge signal. Got it. What about the standard representations and warranties section? What's key there?
This section is where both parties make formal statements about their status, capacity, and key facts relevant to the deal. The Luxembourg SV should represent and warrant things like DM. It's a validly constituted SV under Luxembourg law. Its board has the sole power and authority to make investment decisions, and crucially, that it's not required to be supervised by the CSSF for its current activities, assuming it's an unregulated SV.
And the Swiss advisor.
The Swiss advisor needs to represent and warrant that they have the necessary expertise to provide the services. And critically, they must represent that providing non-discretionary investment advice to this SV does not require them to hold a FinSA license or register as a portfolio manager in Switzerland. They should also state they comply with applicable FinSA rules of conduct when giving the advice. These reps basically confirm the intended regulatory status of everyone involved.
And finally, in the contract clauses, governing law and dispute resolution, any pitfalls there?
This clause sets out which country's laws govern the contract's interpretation and where disputes get resolved. It's often negotiated. The Lux SV might prefer Luxembourg law. The Swiss advisor might prefer Swiss law. Sometimes a neutral law is chosen. The choice matters because different legal systems might interpret ambiguities differently.
And how are disputes usually handled?
Binding arbitration is very common, often under established rules like the ICC or LCIA. Parties often prefer for confidentiality, and because it's generally seen as faster than going through public court systems.
Okay, so that covers the critical bits of drafting the agreement itself, making it a solid regulatory shield. But getting that signed agreement isn't just about lawyers drafting clauses, is it? It's a whole engagement process.
Absolutely. Given how sensitive it is from a regulatory perspective and the multiple jurisdictions involved, it's not like negotiating a simple supplier contract. It's a much more involved, multi-stakeholder process that needs careful coordination.
Who needs to be at the virtual negotiating table for this kind of agreement? It sounds like it's more than just the business development folks.
Well, much more. While the business principles obviously define the commercial objectives, the negotiation team absolutely must include experienced legal counsel from both Luxembourg and Switzerland, and these need to be lawyers with specific expertise in financial services regulation in their respective countries.
Compliance, too.
Critically, yes. Internal compliance officers from both the SV side and the Swiss advisor side must be involved right from the beginning. They're your first line of defense. They're best placed to spot potential regulatory traps in proposed terms or operational setups before they become embedded problems.
Makes sense. So thinking about the negotiation itself, what are the key points the Luxembourg SV team should be focused on? What are they pushing for?
The SV's main goal is to ensure that agreement rigidly maintains that separation wall between advice and management. They'll push hard for very precise language in the scope of services, especially that negative list of prohibited activities. They need to resist any attempts by the advisor to gain any kind of de facto control.
Like veto rights.
Exactly. Things like veto rights over SV decisions, or any language giving the advisor explicit authority to direct other service providers. The SV will also want strong termination rights, especially clauses letting them exit the agreement quickly if the Swiss advisor runs into regulatory trouble or breaches their reps about their licensing status. That could pose a huge risk to the SV itself.
And flipping it around, what are the Swiss advisor's key concerns and priorities in the negotiation?
Their number one paramount concern is regulatory compliance on their end specifically, making absolutely sure the services they provide do not trigger the need for a FinSA license. So they will push very hard for that crystal clear scope definition, making sure their activities stay firmly inside the non-discretionary advice box.
Liability limitation, too.
Definitely. They'll strongly advocate for limiting their liability to that gross negligence standard, emphasizing they aren't taking investment risk. Negotiating a fee structure that is regulatorily defensible, so not based on AUM, is also a huge priority for them. And naturally, they'll want strong confidentiality clauses to protect their own methods and client info.
Beyond the legal wrangling, what about practicalities like costs and timelines? What should people expect?
Costs can be significant, no doubt about it. The main driver is usually legal fees. Getting specialized regulatory advice from experienced lawyers in both Luxembourg and Switzerland is simply non-negotiable. You have to see it as an investment in getting the structure right and mitigating risk.
Internal costs, too.
Yes, don't forget the internal costs, the time and resources spent by the compliance and structuring teams on both sides.
Is there a cost advantage here compared to, say, the Swiss firm needing a full license or the SV becoming regulated?
Yes, that's a key advantage mentioned in the sources. You avoid the direct regulatory application fees and ongoing supervision fees that would kick in if, for example, the Swiss firm did need a FINIA license to manage the assets, or if the SV itself triggered CSS supervision. This advisory structure, if done right, avoids those specific regulatory overheads.
And timeline. Realistically, how long does it take to get one of these complex agreements finalized?
Based on the breakdown provided in the material, a realistic time frame for a properly negotiated complex agreement like this is probably somewhere in the range of 2 to 4 months. That's from the initial contact and due diligence right through to the final signed document.
Yeah, break that down.
Sure. You got the advisor's initial DD on the SV and the asset class, plus initial structuring talks, maybe 2 to 4 weeks, then drafting and negotiating a high-level term sheet, perhaps 1 to 2 weeks. The really intensive part is drafting and negotiating the detailed, definitive advisory agreement that could easily take 4 to 8 weeks, involving back and forth between legal and compliance on both sides. Then final internal approvals and execution, maybe another week.
So patience is required.
Definitely. It's crucial to manage internal expectations. This isn't a quick off-the-shelf contract. It requires careful thought and review by multiple experts.
Okay, so imagine we've done all that. We've successfully drafted the perfect contract, navigated the tricky negotiations, everyone signed on the dotted line, the structure is set, the regulatory risk is managed. We're good to go, right?
Absolutely not. And this is possibly the most critical point we need to stress today. Signing that meticulously drafted agreement is absolutely necessary, yes. But it is nowhere near sufficient to guarantee ongoing compliance and avoid that dreaded regulatory recharacterization down the line.
Okay.
The single biggest risk, the thing that can undo all that careful legal work, lies in the operational conduct that happens after the contract is signed. Day-to-day reality matters most.
What do you mean by operational conduct? How can what people do override a solid contract?
Because regulators, whether it's the CSSF in Luxembourg, FINMA in Switzerland, or maybe others, they operate on that substance over form principle. Not just when they read documents, but when they examine actual behavior. If they ever investigate this relationship, they won't just read the advisory agreement you signed.
What else will they look at?
They will absolutely want to see the SV's board minutes. They'll look at internal emails, correspondence between the SV and the advisor, records of transactions, decision logs, and if that evidence trail shows the SV board consistently just rubber stamping whatever the advisor recommends.
And without any real discussion or challenge.
Exactly. Without any documented evidence of independent deliberation, discussion of alternatives, challenging the advice, or showing their own analysis leading to the decision. If it looks like the advisor is effectively calling the shots and the board is just passively agreeing, the regulator will conclude that the advisor is the de facto decision maker.
So the contract might say one thing, but the operational reality shows something else entirely.
Precisely. And in that situation, the operational reality, the substance, will trump the contractual wording, the form. The relationship will be recharacterized.
With all those negative consequences we discussed earlier.
Yes. The Swiss advisor could be deemed to be performing unlicensed portfolio management from Switzerland. The Lux SV could be seen as that dreaded empty shell, or perhaps an unregulated AIF with an unlicensed manager running it. This is why relentless operational discipline and sticking to really robust governance protocols are simply non-negotiable after the contract is signed.
So what does that look like in practice? What does the Lux SV board need to do consistently?
It means ensuring the advisor's input is always treated and documented as exactly what it's supposed to be. Non-binding advice or recommendations. The SV board must hold proper meetings physically or remotely, but formally convened in Luxembourg where these recommendations are actually discussed.
And the minutes need to be detailed.
Extremely detailed. The board minutes must clearly document what advice was received, what the discussion among the board members was, any questions they raised or challenges they put to the advisor, whether they considered any alternative courses of action even if they rejected them, the specific rationale for the board's final decision, and an explicit statement confirming the decision was made by the SV board itself, exercising its independent judgment.
That level of detail provides the proof.
It provides the necessary audit trail, the evidence of genuine decision-making happening in Luxembourg. It actively counters any suggestion that the board is just a rubber stamp or passively following instructions.
This sounds like more than just ticking boxes. It's actively building a continuous compliance record.
That's exactly what it is. It's an ongoing process of building the evidence file that proves the substance matches the legal form. And, this kind of operational rigor also aligns very well with broader global trends we're seeing towards greater substance scrutiny.
Like ATAD 3.
Exactly. Things like the EU's proposed ATAD 3 directive, the Anti-Tax Avoidance Directive 3, which is all about preventing the misuse of shell entities. A structure that genuinely requires and can demonstrate real substance and decision-making in Luxembourg is inherently much better positioned to meet these evolving international standards.
And the new FinMA circular.
Right. The FinMA circular coming in 2025, with its increased focus on documenting client interactions and the basis for advice, makes this clear delineation of responsibilities in actual operational practice even more critical for the Swiss advisor, too. They also need to show they stayed on the advice side of the line.
Okay, so to bring this fascinating deep dive to a close, what are the absolute key takeaways? If someone is looking at setting up or operating this kind of cross-border advisory relationship for a Lux SV, what are the non-negotiables?
You can really boil it down to 3 core pillars for a robust, compliant structure. First, you need that meticulously drafted advisory agreement with a precise scope of services. It must be unequivocally non-discretionary, using both positive and negative lists of activities, especially that clear list of prohibited management functions.
Pillar 1, the contract scope.
Pillar 2, a defensible fee structure. It must be rigorously linked to specific advisory services provided. Absolutely avoid compensation based on assets under management, the AUM fee, because the regulatory risk is just too high.
Pillar 2, the right fees.
And Pillar 3, strict operational discipline by the Luxembourg SV's governing body. This means ensuring board minutes and other internal records clearly and consistently demonstrate the board's independent thought process, deliberation, analysis, and ultimate decision-making. This proves substance exists in Luxembourg and confirms the advisor lacks practical discretionary control.
So engaging specialized foreign expertise, like from a Swiss advisor, definitely offers a competitive edge for Luxembourg SVs dealing with complex markets or assets. And it's absolutely achievable within the current rules.
It is achievable.
But as we've really dug into today, based on the sources, success hinges on rigorous upfront legal structuring, using that multi-jurisdictional regulatory expertise, and maybe most critically, an unwavering ongoing commitment to proving substance and demonstrating independent control in the day-to-day running of the SV.
The contract gets you started, it sets the framework, but it's your operational records, especially those detailed board minutes, that will ultimately be your proof of compliance if regulators ever come knocking.
Which leaves you, the listener, with a crucial question to consider. When you look at your own operational procedures and your documentation, not just for advisory functions, but maybe for any key delegated services, do they currently provide clear, undeniable evidence of your independent control and genuine substance right here in Luxembourg? This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Hit that like and subscribe button. It was the Luxembourg Fundcast for you today.